Good evening and welcome to NDTV. This is Breaking Views. I am Ankit Tyagi. Ladies and gentlemen, the central government has introduced a bill in the Rajya Sabha on appointment of future chief election commissioners and election commissioners of India. Remember, they are part of the Election Commission of India, which is responsible for conducting the elections all across the country. Now, the said bill, viewers, proposes a 3-member committee for the purpose, led by the Prime Minister, which will also have the leader of opposition and a cabinet minister nominated by the Prime Minister. Now, this diverges from a Supreme Court ruling of March this year, which stated categorically that the committee should consist of the Prime Minister, the leader of opposition, and the Chief Justice of India. So the bill essentially drops the CJI to include a cabinet minister, virtually giving the ruling government a majority in the 3-member committee. Now, if you remember earlier, the process was that the government will send the name to the president, the recommendations, and the president then used to approve the election commission. There were a lot of questions raised. The opposition said that it has to be free from any interference as far as the government is concerned, and that is possibly the reason why this petition was put in. But as soon as this bill, in fact, was introduced, opposition leaders have alleged that the government is undermining the directive from the Constitution bench of the Supreme Court and are also questioning, that's what the opposition is saying, the government's intent behind this change in the bill that has been brought in the Parliament for the appointment of the chief election commissioners and the election commissioners.
आज जो बिल लाया गया है जिसमें माननीय प्रधानमंत्री जी और विपक्ष का नेता और एक कोई सरकार का मंत्री 3 लोगों की कमेटी होगी, तो मैं समझता हूं कि निर्वाचन आयोग को सक्षम बनाने के लिए, पारदर्शी बनाने के लिए, सही ढंग से, प्रभावी ढंग से काम करने के लिए ये जो बिल जो लाया गया है बहुत ही सही है।
ये गैर लोकतांत्रिक बिल है। ये भारतीय जनता पार्टी की, नरेंद्र मोदी जी की इस देश के ऊपर कब्जा करने की साजिश है। 2 बीजेपी के आदमी मिलकर बीजेपी के आदमी को मुख्य चुनाव आयुक्त बनाएंगे और वो बीजेपी के लोगों को जिताएगा, तो देश में लोकतंत्र कहाँ रह गया। मैं प्रधानमंत्री जी आपसे पूछना चाहता हूँ, जब आपने राज्यसभा के अंदर ये बिल पेश किया, क्यों नहीं विपक्ष की सुनी गई?
So is the government, by excluding the Chief Justice of India from the appointment of Election Commissioners Bill, Selection Committee, are they doing anything contrary to the law or in contempt of the Supreme Court? Well, legally, absolutely not. As the Supreme Court judgment clearly states that the states that the judgment appointing the CJI to a selection committee will continue to hold good till a law is made by the Parliament. So now the government has exercised that option, and technically the government has moved to make a new law through the Parliament, and hence they are not in contravention or in contempt as far as the Supreme Court is concerned. But viewers, now remember that the Supreme Court directive had come after questions were raised on the appointment process of election commissioners and with an intent to ensure the independence of the Election Commission of India. So I just want to very quickly at this moment bring you up to speed with what was the spirit as far as the Supreme Court order was concerned, which came on March 2nd, 2023. In its verdict, the Supreme Court had said the elections should undoubtedly be fair and the buck stops with the Election Commission. In fact, the Election Commission is duty-bound to act in a fair and free manner. The Election Commission cannot claim to be independent, then act in an unfair manner. These were, in fact, the wordings of the Supreme Court judgment. The power of the ballot is supreme, capable of unseating most powerful parties. A party in power will have a near insatiable quest to continue in the saddle. Huge surge in role of money, power, and criminalization in politics. The Supreme Court also said a pliable election commission offers the surest gateway to acquisition and retention of power. Democracy can succeed only if all stakeholders work to maintain the purity of the polls. And the Supreme Court then in the end said if purity of elections is not maintained, it would lead to disastrous consequences. Election Commission must remain aloof from all forms of interference from the executive. That, ladies and gentlemen, was the very spirit of the judgment that was passed by the Supreme Court. So, but the government now exercising their right to make a law on this, is it going against that spirit? That is one question that we'll try and discuss. This development, ladies and gentlemen, is also significant because there is a vacancy which is set to occur in the Election Commission, as the Election Commissioner, Mr. Anup Chandra Pandey, is due to retire in February 2024, which will be closer to the announcement of the 2024 Lok Sabha election schedule. The question that we are raising at this moment, Independent Election Commission, does Centre Bill dilute the Supreme Court verdict? Let me very quickly open this up to my esteemed guest this evening. S.Y. Qureshi, former Chief Election Commissioner of India, is with us. We also have Ashwini Dubey, Advocate Supreme Court, and Sanjay Hegde, Senior Advocate Supreme Court, also joining us. Mr. Qureshi, I would like to start with you first, sir. I remember speaking to you when the judgment had come and you had termed this judgment historic. Now you've also seen that the government is coming up with a bill. The change that the government has made is excluding the Chief Justice of India from the selection committee and including a minister nominated by the Prime Minister. How do you see this development, sir?
It is a mixed bag. First of all, it is a compliance of the Supreme Court that a collegium system is being introduced. And a bill has been passed, and Supreme Court had said that till such time that the bill comes, some arrangement was suggested, a collegium consisting of the Chief Justice. Now, collegium is being constituted. The only difference is that CJI has been excluded, and a cabinet minister appointed by the Prime Minister will be the second person. So, now, if the decision making is by majority, obviously the 2-1, the leader of opposition will become totally useless and meaningless. Now, there are 2-3 good and interesting new things which have happened. Now, one, that a search committee has been proposed, led by the Cabinet Secretary and with 2 senior most secretaries of Government of India, and who will select 5 names. Second important thing is that earlier there was no qualification prescribed. Anybody from the road could have been picked up and made a CEC. Thank God it hasn't happened in the last 10 years and it hasn't happened in the last 70 years. Now, qualification prescribed is as a secretary level officer with experience and integrity.
Right.
That's a very good thing. So, therefore, now whether the Chief Justice's exclusion is a good thing or a bad thing, both opinions can be expressed. Their Chief Justice is present in various collegiums, and what has been the performance of those collegiums? Director CBI, CJI is the party, and we have seen a director of CBI about whom IB reported that a criminal went to his house 183 times in 1 year.
Okay.
And but that was the quality of the selection by that collegium. And then even when this was brought out very openly, Supreme Court did not act, Chief Justice did not act, the guy completed his tenure until today, the inquiry has not been completed. So, therefore, that raises another thing. Mr. Hegde perhaps will bear me out. Now, if suppose the appointment of a commissioner is questioned in the Supreme Court. Now, if Chief Justice has been a party to the selection, and he sits in judgment on that selection there, or his subordinate judges sit in judgment, it will be very awkward for a junior judge to overrule what Chief Justice has decided.
It will be basically a conflict of interest there.
There is a conflict of interest. Therefore, keeping him out and having a collegium is fine. But provided it becomes essential that the decision will be unanimous. Which means the leader of opposition will not be marginalized. And it is very easy. And secondly, now, whether this will amount to leader of opposition having a veto power?
Okay.
Not at all. Not at all. Because he will be selecting from a panel of 5 selected by the cabinet secretary, and cabinet secretary is the government's man. 4 extension given. Obviously, he will not spring a surprise on the prime minister by bringing in any undesirable name. So, this selection committee is a good idea, but it has to be unanimous decision.
It has to be unanimous. If it is majority, then of course it is the will of the government that will prevail. But Mr. Qureshi, so overall, in perspective, the whole idea and the spirit of the judgment of the Supreme Court was to ensure that the Chief Election Commission and the election commissioners are above question. There are not doubts which are raised against them as far as the process is concerned. Do you feel that this bill upholds that spirit?
Yes, it can be provided, the condition which I have mentioned to you is implemented. There is another great thing which has happened through the bill, which nobody seems to have noticed it. For the last 20 years, we have been demanding that the CEC is protected from removal. He can be removed only through impeachment. The other 2 can be removed very easily. So they used to feel they are on probation. And if some commissioner feels he's on probation, on the government's instruction, he can overrule the chief CEC 10 times a day. Now, that protection has been given to all 3. That's a great thing and which needs to be appreciated. And with one more sentence, I'll finish my thing because I have to move on to somebody else.
Sure.
One negative thing which has happened, that they have downgraded the status of the CEC and the commission from the Supreme Court judge to a cabinet secretary. Earlier, before Mr. Session, it used to be secretary, now cabinet secretary. Although salary of the cabinet secretary and Supreme Court judge is the same, but in warrant of precedence, in stature, that has been downgraded. I'm sure it is not intentional, and government would like to reconsider.
Very quickly, sir. In the end, I just want to ask you one more question before I let you go. Also, no matter what the selection process is, once you are on that seat, doesn't it also depend on how the election commissioner decides to exercise the powers given to them? I mean, in the end, it's their propriety and responsibility, the chair that they are occupying, isn't it?
Absolutely. I entirely agree with you because it's a matter of individual style and conscience. For 70 years, they've been appointed by the government of the day. Many of them have been absolutely non-controversial. It's a question of conscience. And even during this regime, Ashok Lavasa case, he stood up. O.P. Rawat of this regime was a great CEC. There used to be editorial about him. So it's a matter of individual conscience also, and his backbone and his style of functioning.
Mr. Qureshi, always a pleasure. Thank you so much for joining us, sir. I know you have an engagement. I'll let you go there. But Sanjay Hegde, I want to start with you, sir. We were trying to understand the changes. Now, is this an attempt to dilute the Constitution bench judgment? Is that what your view is on this, sir?
Of course, it's an attempt to dilute the Constitution bench judgment. The Constitution bench judgment was not exactly to the government's taste, but this is what we can expect from this government. If any judgment of a Constitution bench or of a court is not really acceptable, they can change the basis of the law. And that is within their powers. They have the power to do it, but whether it is in good taste, whether the country takes it well, that's a different thing altogether, because this has come very close on the heels of the Delhi ordinance. In Delhi also, there was a Constitution bench judgment which said that personnel should be under the elected government. And they changed the basis of the law there. They've done the same thing here. So sometimes it does seem to me that this government looks at court judgments like many of Delhi drivers look at red lights. It is optional.
But
if you don't like it, you were hearing
what, just one intervention, sir. You were hearing what Mr. Qureshi was saying. He said that there are things that can be appreciated in that as well. He pointed out a very pertinent point that if the CJI is also part of that collegium, then if there are questions raised on the election commission, then there will be conflict of interest. It's better that the CJI is out of it.
I entirely disagree there for one very simple reason. Obviously, the CJI would not be then hearing the case. Number two, The judges of the Supreme Court are not subordinate to the CJI. The CJI is primus inter partes, that is the first among equals. And there have been cases and cases where courts have on the administrative side decided something, like firing a district judge, for instance. But on the judicial side, when they've found something wrong, they've set aside those judgments or those orders, notwithstanding the fact that the CJ of the court was part of it.
Okay.
So I don't see a conflict of interest.
Ashwini Dubey, there are those, Mr. Hegde also articulated this, that this seems to be an attempt to undermine the whole spirit and dilute the Supreme Court order. There are lawyers, those who have gone to the extent of saying that this will be struck down. This is against the Constitution. Legally speaking, at this moment, the government might not be in contempt because the judgment said that the government has to, in fact, pass a bill, and the government has done so. But do you feel that this will stand the legal, constitutional scrutiny if it is challenged in the Supreme Court?
Yeah, Ankit, first, it is a Supreme Court only which has been pushing for the reforms. Reforms, Ankit, vis-a-vis the institutional reform to have a selection process for the appointment of the Chief Election Commissioners and Election Commission. That's a Vineet Narayan case in 1966 onwards. Now, the Constitution bench judgments refers specifically, Ankit, Article 324, Subclause 2, which refers to the appointment of Chief Election Commissioner and other election commissioners, which shall subject to the provisions of any law made in that behalf by the Parliament. So the President has been given powers to make a law. Now the Supreme Court itself in its judgment have categorically said that till the time the Parliament makes a law. So whether the law which has been made by the Parliament, which the Supreme Court has been pushing for last many decades, and the law which has been passed by a legislative body which is having competence to pass a law will be amenable to the Supreme Court. Of course, the Supreme Court can review when its judicial powers can review any law which is arbitrary to the Constitution. But Ankit, there is a difference. Little difference is that when the election commissioner or chief election commissioner are appointed, there are safeguards vis-a-vis that he shall not be removed from his office except in like manner and on the like grounds as a judge of the Supreme Court.
Right.
The conditions of the service of the chief election commissioner shall not be varied to his disadvantage. Now, Ankit, how do you see the CVC's appointment? CVC's appointment is actually also on the same parameters.
Okay.
So even otherwise, its government's process is only till the appointments. Rest of the functionings has to be regulated by the CEC and EC itself.
Okay, but Mr. Hegde, you know, like you mentioned the Delhi Services Bill as well, will this create another friction point between the government and the judiciary? Do you see this as a collision point? I mean, it's the second judgment of the Constitution bench after the Delhi Services judgment that has been, the legislative route has been used to overturn that in a way. And we have already seen the differences as far as the appointment of judges is concerned. Do you see that escalation between the judiciary and the government on this?
I don't think that there will be an escalation because the judiciary is mature enough. The judiciary's job is to interpret the law as enacted. Thereafter, if the basis of the law is changed, then it examines the new law for constitutionality. What the judiciary has so far said about this kind of process is that you may change the basis of the law, but you cannot directly overrule a judgment. If a judgment is on facts, if a judgment is on the basis of the Constitution itself, then without changing the Constitution, if you only pass an act of Parliament. So you have not changed the basis of the judgment. The old judgment will then have to prevail. Okay. So this kind of examination, re-examination of the new law will certainly happen. But I think both institutions are mature enough to not see it as some kind of battle of wills, but that which is a necessary process of political life.
Very quickly, Mr. Hegde, do you then see, one step forward, two steps back as far as the whole idea that was enshrined in that judgment about the independence of the Judiciary, of the Election Commission with this bill coming in?
Yes, of course. See, it is like saying that we are going to have the World Cup shortly. So if India's captain, vice captain, and Australia's captain were to decide who the umpires were, to the exclusion of everybody else, how fair would that process be?
Mr. Dubey, just picking up from what, in fact, Mr. Hegde is saying, you said that the court had, in fact, mandated that this should be brought in. There are no two ways about that. But in terms of perception and also the whole idea of keeping the Election Commission free of any interference, does this, I mean, don't you think that this is now all set for another legal battle? This will, at least perception-wise, not look good on the government.
No, of course, anyone is aggrieved by this bill may challenge it to the Supreme Court. It's a fundamental right. But the question, Ankit, herein is, when the office of the Election Commission is an independent constitutional body and which has been vested with the powers of superintendence, direction and control of the preparation of the electoral rolls and also conduct of all parliamentary state legislatures elections, and that too when there are various safeguards, not in one judgment, but number of judgments, the safeguards have been given to the Election Commission. Where is the question of arbitrariness? But of course, the Supreme Court, within its judicial review, has ample powers. It finds that the powers are arbitrarily being exercised or have been exercised by the Parliament by making this law in order to gain the political benefit. And of course, it can be challenged. But so far as the legislative competence of making a law is concerned, Ankit, how will we deal with that? Okay. How can we take it that power? That the Supreme Court judgment, 5 judges judgment led by the Honorable Justice K.M. Joseph. In his view, he has articulated this that till the time the Parliament makes the law. So let's see what will happen tomorrow. But as of now, how will you deal with Article 325 or subclause 2? Because that's deal with the power to make the law.
That's
yes,
right.
Over to you.
That's right. There is no infringement as far as that power of the judiciary, of the executive is concerned to make the laws as they deem fit. Of course, it can be, it can go through the scrutiny of the Constitution in a constitutional court. But gentlemen, thank you so much for sharing your views on the broadcast. That's all the time that I have on this edition of Breaking News. Ladies and gentlemen, this debate has just started. This bill has been tabled in the Parliament. There is going to be debate, or hopefully a very sound debate. It's a very, very important bill that is going to decide a lot of things as far as the free and fair election process is concerned in the country through the Election Commission. So that's all the time that we have in this edition. Thank you so much. Good night.